Let us start understanding the definition of offer and acceptance and the legal provisions relating to the offer and acceptance. So let us start with offer. Offer is the starting point in making an agreement. An offer is also called as proposal. So, as per section 2a, when one person signifies to another his willingness to do or abstain from doing anything with a view to obtain the assent of the other to such act or abstinence, he is said to make a proposal. So, we have already discussed this definition. So, let us understand the essentials of offer. So, the person making the proposal or offer is called as promiser or offerer. So, basically, while making an offer, it must be made by one person to another. So there must be two parties, isn't it? So one is offerer and another is offeree. So it must be made by one person to another. Basically, there can be no proposal by a person to himself. So there has to be two parties. And another one is it must express the willingness. The party who is making an offer must express his final willingness or readiness, what we call it as, to do or abstain. To do or abstain. So here we have already elaboratedly discussed in our earlier sessions that, for example, when Mr. A offers to sell his car to Y for 1 lakh rupees, it is a positive act to do. Whereas not to do something means when Mr. A offers not to file a case against Y if Y pays A the outstanding amount of 1 lakh, it is a not doing an act. So this we have already elaborately discussed in our earlier sessions that has to the abstinence. Please refer our previous unit discussion. And that is what here we are saying, that an offer can be positive as well as negative. Students, don't get confused by the word negative. Here negative is nothing to do with illegality. So positive means to doing an act, and not to do means a negative. So not doing, not teaching, not working, not doing specific acts which are specified in the agreement. So these are, we call it as abstinence or not to doing something. And it must be made with view to obtain the assent. So whenever the final willingness is being made by the offerer, it has to be with a view to obtain the assent of the other. So whenever a party is jokingly makes a statement or offers, it will not be considered as valid offer. So the offer has to be real, and it has to be the final willingness. It is not merely the intention, it has to be the final willingness to perform, so that if the other party gives consent, it has to be performed. Moving to the next segment, the classification of offer. We have various types of offer here. So let us start with offer. General offer. General offer is an offer made to the public at large. So it whenever the offer is made by the offerer, it creates a liability in favor of any person. Any person. So, as against the specific offer, general offer creates a liability in favor of any person who fulfills the condition of offer. It is not necessary, students, that offer it to be known. So, any person can accept it. So, in this case, generally in general offer, the offeree may be the unknown person also. So, at the time of making offer, the offerer need not have to know about the offeree. So that is why we call it as general offer, wherein it was made to the public at large. For example, if Aditya advertises in the newspaper that any person who found his lost pen can get a reward of 5,000 rupees. So any person who finds the pen can claim the reward. So that is how the general offer works. So there is a famous landmark case law, Carlyle versus Carbolic Smoke Ball Company. So in this case, what had happened was the company, Carbolic Smoke Ball Company, gave an advertisement that they will compensate if anyone gets contracted with some disease called influenza after using their smoke balls. So Mr. Carlyle, who purchased and consumed it and got contracted with influenza, so even after using it as per the printed instructions, so when she wanted to claim the reward, the company refused and rejected the claim of Mrs. Carlyle on the ground that offer was not made to her specifically, and that in case she had not communicated her acceptance to the offer. So it was held in the court of law that she can recover the reward as she had accepted the offer by complying with the terms of the offer, which where the offer is made to a specific person, it is only that person who can accept it. But however, in the case of general offer, any person, even though he may be a stranger, after complying with the conditions of offer, it is deemed to have accepted the offer. So general offer, where it is offer made to the public at large, and hence anyone can accept it. So in terms of section 8 of the act, anyone performing the conditions of the offer can be considered to have accepted the offer. Until the general offer is retracted or withdrawn, it can be accepted. So time limit, they are saying that within the time limit it has to be accepted, even though the general offer, if it is accepted within the time limit and as per the terms and conditions, then it is deemed to be an contract, and accordingly the offerer has to fulfill his obligation. This is all about general offer. Specific offer is the offer made to a specific person or ascertained person. It is known at the time of entering into a contract. So specific offer is made to the specific person or a specific group of persons. So offeree should be known to the offerer at the time of making the offer. So in nutshell, it can be accepted only by that specified person to whom the offer has been made. So for example, Aditya offers to sell his car to Pradeep. So here only Pradeep can accept or reject it. So no other person can accept it. Since this is a specific offer, it can be accepted only by the person or the group to whom the offer is made. So this is all about specific offer, wherein there is a famous case law called Bolton versus Jones is the landmark judgment. With respect to the cross offer, when two parties exchange identical offers in ignorance of the other's offer. So at the time of making an offer, the parties do not know that other person has offered. So this we call it as cross offers, wherein when two persons make identical offers to each other in ignorance of each other's offer. So this is called as cross offer. One offer cannot be taken as offer and the other person's offer cannot be taken as its acceptance. So there cannot be a concluded contract in such case, because both the parties have become offerers and no one is there to accept it. So in such case, contract cannot be considered as concluded and there is no valid contract existing, because one party is offering without knowing the other party is also offering without knowing the other's offer. So there are, both the parties have become offerers and there is no one to accept it, hence it cannot be considered as a valid contract. And moving on to the next discussion, counter offer. So counter offer, when the offeree offers to qualified acceptance of the offer subject to modifications and variations. Students, when there is a counter offer, the original offer gets terminated. What happens whenever the offerer is making an offer, in order to consider it as a contract, the offeree has to accept it without any modifications. So acceptance subject to the modifications or variations cannot be considered as valid acceptance as per the provisions of law. So hence, when the offeree offers another offer with a revised terms and conditions, he has said to be made a counter offer. So basically, whenever an offerer is offering, the acceptor has to accept it without any qualification. It has to be accepted absolutely without any conditions. For example, Mahendra offers to sell his car to Narendra for 4 lakh rupees. So Narendra says he would accept it for 3 lakh rupees. This is not a valid acceptance but a counter offer by Narendra by stating 3 lakhs, which Mahendra need not have to accept it. Mahendra may accept or may not accept, but however, in this case, Narendra has made a counter offer. And in the last case, standing offer, wherein it is also known as the continuing offer or open offer. Standing offer is a continuing offer or an open offer which is allowed to remain open for acceptance over a period of time, which is known as standing offer or continuing offer. Generally, tenders, we call it as standing offer, wherein the offer remains open for a particular period of time, wherein the acceptor accepts it as and when he needs the goods. So, this is the explanation for the classification of offer. In the next sessions, we will be discussing on the validity about the offer as to the legal rules of offer.